Hi, welcome back. This week, which is week 8, module 7, we're going to talk about jurisprudence. This module focuses on the application of legal reasoning through rules and standards, slippery slopes, acoustic separation, and property rules and liability rules. There's 3 readings: Kaplow's Rules versus Standards, Rizzo and Whitman's The Camel's Nose is in the Tent, and Levmore's Unifying Remedies, as well as looking at the next chapter of the book. There are lecture notes on all of these that summarize the articles, starting with the Kaplow article, Rules versus Standards and Economic Analysis. Lewis Kaplow's Rules versus Standards delves into the comparison between rules and standards. It provides a thorough economic perspective on their application and impact, and Kaplow explains that rules are specific, detailed prescriptions of behavior, while standards are broad and general, leaving much to be interpreted in specific cases. He aims to analyze the conditions under which one approach might be more advantageous than the other, considering factors like administrative costs, compliant costs, and predictability of the law. In his analysis of rules, Kaplow highlights that they tend to have higher upfront administrative costs due to the detailed work required to establish them. However, their benefits are that they lower compliance costs for individuals and businesses because the expectations are clear and straightforward. People know what they need to do under rules. Rules also provide greater legal certainty. This reduces litigation costs and the burden on judicial resources, again, because people are adjusting their behavior because they clearly understand what the rule expects them to do. Despite the advantages, rules can be rigid and might not adapt well to changing circumstances or unique cases. This leads to some suboptimal or not positive outcomes. On the other hand, the difference between standards is that standards are characterized by their flexibility. They can be applied to a wide variety of situations. They can be adapted to changes and unforeseen circumstances, and this leads to more just outcome in individual cases. However, standards have higher compliance costs since individuals and businesses must spend more resources to understand how the standard applies to them. And the use of standards can increase litigation costs and place a heavier burden on the judicial system. Kaplow concludes by emphasizing the importance of balancing the trade-off between rules and standards. The choice between the two, he states, should be informed by a careful analysis of the specific context and the costs and benefits associated with each approach. And he talks at great length about when one benefits the other. In some situations, a combination of rules and standards might be the most efficient solution, capitalizing on the strengths of both approaches while mitigating their weaknesses. An example that we can see where this is accurate, I gave you some examples in your notes, real life examples, but for instance, in traffic regulations, this is the first example with speed limits. A speed limit sign that says the speed limit is 55 provides clear, specific rules. The drivers know what they need to do. Law enforcement can interpret it. Its pros are clear expectations, easy enforcement, low compliance cost. The cons are inflexibility. You're not able to adjust for unexpected situations, such as there's a clear open highway with no traffic. Standards, on the other hand, is if the sign said drive at a safe speed. This would be a standard. It's flexible. It can adapt to different driving conditions, but it leaves lots of room for interpretation by both the driver and law enforcement. The pros are that it's flexible to adapt to different situations. Cons is higher compliance costs, as the drivers have to evaluate what safe speed means, and enforcement costs then also are then higher because it's a judgment call, leading to more judicial resources, more disputes. There's a couple other examples in your reading as well. I want you to pay attention to the conclusions on page 621 of the article, which talks about that the article itself is looking at an economic analysis of rules and standards, focusing on the extent to which the law should be given content before the individual acts, which is rules, rather than waiting until afterwards, which is standards. The central factor influencing the desirability of rules and standards is the frequency with which the law will be governing conduct. is more costly to comply with standards because it is generally more difficult to predict the outcome of a future inquiry. So in the conclusion, he then states that when behavior is subject to the relevant law is frequent, occurs often, standards tend to be more costly, and the result in behavior that conforms less well to underlying norms. It results in that. If behavior is subject to the law is infrequent, however, standards are likely to be preferable. So that's where he differentiates. He also talks about that in cases where it is anticipated it will arise frequently. This is on the next page. If it's anticipated to arise frequently and have important reoccurring characteristics, rules will not only be preferable, but will be expected to be more precise. Rules are announced in advance and are more likely to influence actual behavior. When a law will govern much behavior, there's a substantial benefit to an early determination of its content. That's when rules are preferable. Moving to the next article in this week's reading, that is the article by Rizzo, The Camel's Nose in the Tent, Rules, Theories, and Slippery Slopes. This explores the concept of slippery slopes in legal policy and policy contexts, examining how initial changes in rules or policy can lead to broader unintended consequences into the future. Rizzo emphasizes the importance of establishing clear rules and principles to guard against these slippery slopes. He argues that when decision makers deviate from established rules based on unique cases or expectations, it creates a precedent that can erode the integrity of the original rule, leading to a gradual shift in policy and legal standards. Rizzo highlights the significance of rules and theories in providing stability and predictability in legal and policy decisions. However, when exceptions are made to the rules based on ad hoc reasoning or case-specific consideration, it can lead to a shift in the underlying theories that justified the rule in the first place. This shift then can pave the way to further deviations from the original rule that creates a slippery slope. Rizzo argues that decision makers should resist the temptation to make exceptions, even in seemingly justifiable cases, as this can set a precedent for the future. He looks specifically in his article on page 542 at 3 objections from the perspective of rational choice, talking about slippery slopes or mega arguments within arguments. First thing he talks about on that page 542 is Ottoman objections. If the future decision, the danger case in the slippery slope, is bad, but the prior decisions are good, why don't we just simply refrain from making the bad decision down the road? Number 2, he looks at the imputation objection. If the consequences of a sequence of decisions are undesirable overall, then why are we tempted to defect from the right path right now? So why are we going down that slippery slope to begin with? And the third objection he looks at is the presentism objection. The mere fact that the ultimate decision appears undesirable from today's vantage point does not mean it will appear undesirable tomorrow. So that we might be fearing something that we decide in the future might actually be where we want to go. He talks about definitions and clarifications of the essential characteristics of slippery slope arguments. That happens on page 544, and the key components of a slippery slope argument are listed there. That number 1, there's an initial seemingly acceptable argument and decision. 2, there's this danger case, a later argument and decision that are clearly unacceptable to the decision makers of today. And number 3, a process or mechanism by which accepting the initial argument and making the initial decision raises the likelihood of the acceptance of the later argument and making the later decision. That we are starting on that slippery slope, that we start here and the anticipated outcome goes a direction that we're not anticipating. He looks further and distinguishing on page 545 slippery slope arguments and slippery slope events. He states that a slippery slope argument, which throughout his article he then calls an SSA, is an argument about how the acceptance of one argument regarding a decision, act, or policy may lead to the acceptance of other arguments regarding other decisions, acts, or policies. It has a hypothetical form, if this, then that, with increased likelihood. That is the slippery slope argument. He then differentiates that from a slippery slope event, SSE, which refers to an actual manifestation of the events, the decisions, the acts, or policies described in the slippery slope argument. So he gives you those definitions on what slippery slope is, and then goes at great length talking about various different slippery slope decisions and how our present decisions can make certain future decisions harder to resist by lowering their perceived cost or increasing their relative benefits. Some examples of this are included in the lecture notes, and an example of this would be, for instance, a freedom of speech on college campuses. The scenario, a college campus establishes rules to protect freedom of speech. However, exceptions start to be made to restrict speech that is deemed offensive or harmful to certain groups. So the explanation here is that while the initial rule supports open dialogue and diverse viewpoints, making exceptions for offensive speech creates a slippery slope. The underlying theory of free speech is compromised, and over time, more types of speech could be censored, leading to significant restrictions of freedom or on the campus. So creating those exceptions to the rule then creates this slippery slope that takes us to a very different point than what the rule was originally intended to do. Let's look then at Levmore's unifying remedies, property rules, liability rules, and startling rules. This article critically examines the existing framework of legal remedies, particularly focusing on the categorization introduced by Calabrese and Melamed, who separated legal remedies into property rules and liability rules. Levmore acknowledges the transformative impact of their work while highlighting its limitations and the potential for further development in understanding legal remedies. He emphasizes the necessity of exploring new and innovative remedies that have emerged since the original framework was proposed, with the aim at developing a more comprehensive and unified theory of legal remedies. You can look specifically at his article on page 2152. This is a summary of the Calabrese Melamed framework, which originally had 4 separate rules. Those rules being the classic property rule, that B, the injured party can stop A from doing what they're doing, the harmful behavior. Rule B is that A pays B. This is the liability rule. A harm B, they pay for that. Rule C of the original framework was the reverse of Rule 1. B loses to A's property right. A can continue to do what A was doing before, despite B's claim of being harmed. And Rule 4 is analogous to eminent domain, where the government can come in and seize things, but is likely to involve low damages. So the government can determine a value, but it's typically lower than a private party would have to pay. And so Rule 4 is B stops A, but pays A's damages. There's little restitution for B. Levmore delves into the intricacies of the legal remedies, considering how rights, remedies, and private bargains are combined to serve a variety of functions while upholding values of efficiency, fairness, and redistribution. And he brings attention to startling rules, a category of remedies that break the conventional norms, such as requiring a party in the right to pay when they have been wronged, giving them an option to stop the conduct through their payment instead of accepting damages. Levmore argues that these can play a crucial role in encouraging honest claims and enhancing the integrity of the legal system. In other words, providing a wider framework in which there can be a resolution of a case means that both parties, he makes the argument, are more likely to do only claims that they know they can justify in court. So they're not as willing to create wider gaps in the positions that are not legally supportable. His work also revisits the Calabrese-Melamed framework, identifying gaps and areas left unexplored, and he highlights contributions from scholars such as Krieger and Schwab that add depth of understanding to legal remedies and introduce new perspectives and possibilities. Levmore seeks to expand the application of the Calabrese-Melamed framework beyond traditional property and tort law, advocating for a comprehensive approach that encompasses a broader range of legal disputes and remedies. He's looking for a more holistic understanding of legal remedies. So in contrast to that 4-rule framework that we saw on page 2152, when we go to the conclusion of his argument, his appendix, the summary of remedies that he discusses in his work on page 2173 of Levmore, he now has a variety of rules. He has sub-rules within Rule 1. He has sub-rules for Rule 2. And he still maintains Rule 3 and 4, but he also adds 2 other rules. Rule 5, A stops and collects B's gain from the cessation, from them stopping their action. But A also not only can collect the gain from B, they could just opt for Rule 3. And then a subpart of that is that A can continue but pays its own enrichment. However, it's enriched from doing its behavior, it then has to pay for that enrichment. So there's, in this summary on 2173, is exactly what Levmore is attempting to do here, where he's trying to advocate for this comprehensive approach that encompasses a broader range of remedies and resolutions in cases. Some examples are given in your notes. I'll look at the first one in eminent domain and compensation. States to imagine a situation where the government decides to build a new highway and part of the planned route goes through privately owned piece of land. According to traditional property rules, the government has the right to seize the private property under eminent domain for public use, but they must provide just compensation. In relation to Levmore's work, this scenario narrows Levmore's discussion on startling rules, where a party in the right, the property owner, ends up receiving payment as a remedy. Here, the government's action is justified for the greater public good, but the property owner is compensated for their loss, compensating a blend of property and liability rules. So the government gets the property owner doesn't retain their rights, but they are the one that is compensated because we're letting them under liability rules be compensated. Property rules is the eminent domain and takes away that ownership right. The last reading for this week is chapter 8 of the book, and it's looking at turning the analogy into identity. So it's going again to Arrow's theorem and the social choice theorem, and then expanding them and stating that specifically whenever a decision-making is multi-criterial, when it attempts to synthesize a variety of criteria into a final choice, it is doing something that is closely analogous to synthesizing the preferences of a variety of voters in final ranking. The application of legal rules can be thought of as an instance of multi-criterial decision-making. This is at the first page of the chapter 107. He then talks at 108 about a sensible multi-criterial decision-making method that Arrow says should meet the following criteria. So the Arrow theorem of voting then gets applied to multi-criterial decision-making, bottom of page 108. Arrow states it first should be intransitive, same rule that we had before, that if you rank A above B and B above C, that you should not be ranking C above A. Second, the method should respect unanimity. So if you're looking at price, safety, and the looks of a car, and A is better than car B, the method should rank A above B, exactly the same as the original theorem. Number 3, that the method should be genuinely multi-criterial. It should not simply go by price or safety of that car or looks, that it has to look at all of those things, and this is then the direct analogy to the requirement that voting methods cannot be a simple dictatorship, that one criteria alone cannot be the decision maker. It needs to be a multi-criterial. And the fourth and final requirement in this analogous theorem of Arrow is that it should, the final requirement Arrow would impose is that in deciding how to rank car A relative to car B, it should not matter whether car C is also an offer. Again, this is referred to as the irrelevant alternative. This is top of page 109. The Arrow theorem then states that there is no method of multi-criterial decision-making that meets these extremely modest-sounding basic requirements. So again, his theorem, he says, these seem simple requirements. We're not able to meet those. So the first example that the author gives you is contrived defenses, starts on page 109. And he's looking here about whether or not you can have that contrived scenario where you create a fact pattern where you want to murder someone and you create a fact pattern where you have the right to do that. So he is looking at proportional punishment when there are three possible options: retreating, allowing oneself to be injured, and killing one's attacker. That there's a rights principle when only two of them exist. If you can only allow oneself to be injured or killed or kill the attacker, then you have self-defense, justifiable self-defense. You have the right to kill the attacker. But when we add in what could be considered an irrelevant alternative, that being retreat, that this produces a loophole, he calls it a loophole on page 112 in the homicide law. The opportunity to a contrived defense is removed by having the retreat option because the availability of the retreat is highly relevant under criminal law. It shows that the irrelevant alternatives really are not irrelevant. In fact, the retreat option in this scenario is extremely relevant because if you have the option to retreat, that option takes away your right to make the argument, the self-defense argument, that you needed to murder the person. So he also talks then on page 113 that it's hard to view the contrived self-defense as an agenda exploitation. So then looking then at the bottom of page 113, he looks at this whole scenario and asks the questions that he's previously asked regarding loopholes. Why does this loophole arise? And the answer is because we are trying to rank three alternatives in such a way as to at least partially accommodate two different principles. Those principles being your right to self-defense and also that murder is wrong. Those principles. How do we weigh those? Why does this loophole persist? The answer is because we don't want to abandon the two principles that we have. And the third question is, what should lawyers do about the loophole? And his answer is, feel free to exploit it with all the verve of a skilled and determined parliamentarian. He looks at the same fact pattern and asks those same questions then at the bootstrapping argument. Here he talks on page 114 about the principles in the bootstrapping example, that being the would-be immigrant who puts themselves at risk through their dialogue in the United States so that they can't return to their country. That here the principles, the two principles that we're balancing are our desire not to admit the entire world into our country, to have borders, to have an immigration policy, but we have to weigh that against our desire not to deliver someone into the hands of a death squad or a concentration camp. So once that person makes it so that they can't return to their country, they create that loophole, then we don't have that option for them to peaceably return to their country. It's taken off the table. Talks about the same kind of scenario on page 115, asset protection, where the two conflicting principles, he states, are the desire to make people pay their debts in a bankruptcy and the desire to not deprive them of basic necessities such as their home, old age pension, or essential parts of their personhood such as gold teeth. And so this situation, then he says, is on all fours with the two prior cases because, again, we have these competing principles that when we add a third option, change which option the person is entitled to use. He discusses it then again in the same situation we had talked previously about in loopholes, tax shelters, page 117. He then talks about the balancing the earning principle. The earning principle is that you should pay taxes on everything that one earns versus the use principle, who's using that asset. And so again, in that case, once you have two options versus three options, the options which are the preferable options by law, change because of that irrelevant alternative or option, which is really not irrelevant. So he comes to the conclusion on page 118 that he is making the general claim in this book that as long as the legal doctrines are multi-criterial in character, which virtually all legal doctrines are, loopholes are bound to arise. So he talks further about the loopholes and about lawyers' advocacy or framing on page 222, where you try to present the best argument and framework for your client's position, because by framing the argument a certain way and the facts a certain way, that's going to influence the decision maker. So going to page 123, his analysis of loopholes suggests that what a lawyer is really doing when he tries to characterize the facts in one way rather than another, when the lawyer's framing, advocating for their client, the lawyer is injecting into the agenda an alternative that he hopes will lead us to take a different view of the alternatives previously considered. That's what your closing argument's about. That's what your briefs are about in an appellate situation. So he comes to the suggestion on bottom page 123 that his suggestion is that what the redescription often amounts to is injecting of a hypothetical alternative into the choice set, which, if they were actually present, would change the choice made. So advocacy is the irrelevant alternative. Page 123, he states, we're now in a position to understand that any approach to legal decision making, including one that is concerned with welfare maximization, is bound to be multi-criterial in nature, and multi-criterial decision making we now know is vulnerable to manipulations, aka loophole exploitations. And that's his conclusion for that chapter. Hope that helped you with your work, and see you next week. Thanks.